All right. Hello, everyone. And if you're listening to this, I'd like to say sorry for what you're going through. I know it's not easy. Uh, I'm regularly getting phone calls from people asking me if I'm still in the uh, mortgage auditing business, fighting the banks, fighting the foreclosure. And the honest answer is no, I am not. I discovered in I discovered in 2016 that the judges really didn't care what was right, where the truth was. Didn't matter if you had real evidence that you were bringing into the court. They would allow me to come in as an expert witness and talk about these things. But when I came in as an expert witness, they wouldn't allow the attorney, the defense attorney, to ask me any questions. Well, it doesn't matter if you have a gun on you. If you're not allowed to pull it out of your pocket, it's not any good. And that's the way it went. So once it became obvious to us that the court had given up actually hearing foreclosure cases, I stopped going into court as an expert witness because there was no sense for me to take your money when it was going to be allowed anyway. Even though we were doing everything we're supposed to do, we provided real evidence, the court wasn't hearing evidence. So here's my best recommendation for any of you. If you have to fight foreclosure, fighting it in the foreclosure court is really not going to get you anywhere. Okay, at least not in the state of Florida. What I highly recommend is that while you drag your feet and go through the foreclosure process, first off, answer everything they send you on time. They say you got 20 days to answer. You need to answer. In that answer, it needs to say, I've received your request. I'm going to make my basic answer that I've received it now. However, I'm asking for a increase of time so that I can file the individual answers to the complaint. Okay, so your initial answer should come at the end of that 20-day period, basically as an enlargement, asking for more time to answer the complaint they put against you. Normally I ask for 90 days. If they don't grant the 90 days, they'll come back and say, we're only going to give you 45 days. Okay, well that's 45 days more than you had. And it puts you in charge of the court schedule at this point. You need to answer every question that they have on there. Usually your answer for every statement they made is either going to be denied or agreed or accepted. Okay? These are really the only things you need to write down. You don't need to write long explanations. Now, there's your answer and then your affirmative defense. If you don't have a lawyer, affirmative defense means these are my explanations or my evidence of why the court is wrong or the plaintiff is wrong. Okay? If you don't have a lawyer, find a why did I forget that word? Find a paralegal who can file these things for you or write it up for you. It shouldn't take that long. It shouldn't be that difficult. The bottom line is you're not going to win in that case. You can argue, you can delay, you can stall as long as you want. You can probably stall them off for, in many cases, we were able to stall people for 2 to 5 years that the bank could not take the home. They were in their home without making a payment for 2 to 5 years, just going through the foreclosure process, answering every question, denying everything that they tried to put forward, dragging their feet until the time had passed. Hopefully you're saving your money during this time, because at the end of the game, you're either going to have to pay something off or you're going to have to move. So save your money during this 2 to 5 years when you're fighting them, or 6 months if it doesn't go that long. When it comes down to the actual time that you've lost and they're getting ready to sell your home, now just before they file just before they're supposed to have the actual sale date at the courthouse steps, the day before you need to file a suggestion of bankruptcy. That's the BK 13 or bankruptcy 13. Not a 7, which is about giving away your stuff, but a chapter 13, which is about keeping everything. Okay? when you file it, at the time that you file it, fill out all the documents in advance. There's a website that you can go to for bankruptcies. Just go online, look it up for your area. And as you file the paperwork, they're going to ask you about filing your financials. These are the papers that say this is how much I make and when I can pay back these different debts, because you're keeping everything. You have to make a payment plan. And you're just going to simply tell them that you'll file that later. They're going to ask you, do you want to make any payments now? Your answer is going to be no. They're not asking if you're paying to file. They're asking if you want to pay anything towards these different things. Your answer was no. They're going to put it in. They're going to give you at that time a case number for this federal case. As soon as you get that number, you take it over to the county courthouse where you have your foreclosure case and have that entered, just that thing where you filed the suggestion of bankruptcy, have it entered into your foreclosure case, and instantly that case is stopped. There's a cease and desist order that's going to enter, and they're not going to be able to go forward with the sale. 2 to 3 weeks are going to go by before that you haven't put in your financials. At that time, they're going to kick the case out because you didn't do your part, the BK we're talking about. And sometime after that, the plaintiff or the bank is going to have to refile for a new sale date. Could be 6 months, could be a year, could be 3 years. Just depends on the bank. Every time they get a sale date, the day before they do the sale, you need to file the suggestion of bankruptcy. You do it probably 3 times under each spouse. So that's at least 6 different times, and usually you get a year or more in between them filing for a case number. So short answer is no, I'm not doing these cases anymore. There's not, in my opinion, a good route in the foreclosure area and doing it. If you seriously have a real lawyer that wants to fight it through the bankruptcy, and you're actually pulling your documents out and you can show where they falsified your documents and did these different things, that's great. There are arguments that can be done in a bankruptcy court. But if you're not in the bankruptcy court, you really don't have much power. And the best way I can see to use it is to use it as a way of stalling as long as possible while you put your capital together and plan on where you really want to be next. All right. God bless. Hope this helped you out. And if you know me, you know where to find me. Talk to you later.